Welcome to another episode of the Untitled Legal Attempt with me, George Sintangwa Malipilo. Thank you for tuning in. This is episode number 10. So we have a full 10 episodes. Wow, wonderful guys, wonderful. We make these for you. So clap for yourselves. The fact that you continue listening and the fact that I continue making them is a sign that you people appreciate what I do. I just want to help people understand this legal law. Is it legal law or this law and its huge terminologies in a much simpler term? Now, we're close to 200 downloads and it's all because of you. So thank you very much. I mean, I thought we would just end up with 12 in the end. So I was like, whoa, okay. All right, let's move on to today's case. So today's case is Angela Musonda versus Paus Financial Services Limited. Court of Appeal for Zambia 132/2017. Yes, it's a Court of Appeal judgment. It's a landmark judgment because it also has a Supreme Court judgment. So meaning we can still use it. So the brief facts of this case were Angela Musonda sued Paus Finance Services Limited in the High Court. Now the argument was whether or not Paus Financial Services Limited had the right to seize the Mercedes-Benz Angela Musonda had put as security for the loan agreement that she had obtained from Paus Finance. Now, the nitty-gritties of the loan agreement were that she was getting a sum of 45,000, and it was agreed in that loan agreement that she would pay it back within a period of 36 months. So the equal installments were to be made within a period of 36 months and an interest of 3.5% per month. So the amount that she was supposed to pay, the total amount that she was supposed to pay back was 79,804 and 34 ngwe. That makes sense. Now the security that she had placed, I've already stated, was the Mercedes-Benz. Registration number BT5027. Now the security is the protection to the loan. Okay? Now, in this type of agreements, what you must understand is we need a fall guy. In case the money is not paid back, I can use that security as my backup plan. That's why it's a collateral. It's more like a mortgage as well. With mortgages as well, it's a security for a loan. So the mortgage or the collateral act as the same. You have a backup in case the person doesn't pay so that you don't lose out. Because at the end of the day, you are giving someone money with the prospect that that money might be given back. Now, there were other things that happened in this case of Angela Musonda versus Paus Financial Services Limited. So I'll just skip right through them at a quick beat. So Angela Musonda made a preliminary application to the court ordering that this truck should not be sold while the matter is being heard. Okay? Now, sadly, the truck was already sold. So this application, even though the court had granted it, stating the fact that you cannot sell seized property that is used for business, it was overtaken by events. So even if the court was saying this was a tool of trade and it cannot be sold, it was overtaken by two of events. It was already sold. So Angela Musonda felt that Paus Finance Services Limited was actually acting contrary to the court order and contempt proceedings were brought forward. But I mean, come on guys. They had already sold the whip. They had already sold the vaca. So what do you expect? For them to just magic, we bring back the car? No guys, no. But anyway, the matter did proceed and the court didn't go forward with the contempt of proceedings because, like I've said, magic beans. Alright, so in making the decision, the High Court of Zambia looked at the agreement and said, actually, Angela Musonda had defaulted on this loan agreement. And therefore, Paus Finance Services Limited had the right to sell that that Mercedes-Benz truck. I was thinking of BMW. That Mercedes-Benz truck, okay? They had the right to sell it. They sold it for 20,000 and they got 17,000 cash. So the court then said, from that 17,000, the remainder of the money that you, Angela Musonda, owe is 36,642 and 71 ingwe, which you have to pay back because you defaulted on the loan, and the loan was clear how much you were supposed to pay, and any default meant they could exercise their right as the person who borrowed you the money to the creditor use the security which you pledged in the event you failed to pay. So that matter was decided in the High Court. Now, Angela Musonda, dissatisfied with the judgment of the High Court, said, we're going up. All the way up. Okay, that's... yeah, but it was all the way up to the Court of Appeal. So she was challenging the decision of the High Court and was arguing, say, it was still illegal. And because it was illegal, she was asking that she be given damages because she had suffered injuries. Damages are basically injuries in law, and we must give you more of a relief, which is called a remedy, to take you back to the position you were. And we shouldn't overpay you. That's the whole purpose of asking for damages, because you're injured. So we need to take you back to the position you were if that action did not happen. I think you should see the case of Professor Chilwa versus the Zambia Railways Limited and the Attorney General, who talks about damages and their main purpose. Okay, now when we get back, we will look at what the Court of Appeal ruled in this matter. Then we'll proceed to why we picked the case and why we think it's of an important caliber to the Zambian legal system. So for now, some Ben sound. I'll be right back. All right. We are back. So, Angela Musonda took House Finance Services to the Court of Appeal, appealing against the judgment that went in their favor. Now, in these instances, when the plaintiff or the person that sues loses a matter in the lower court, the Supreme Court ruled in a lot of cases, costs follow the event. So what I'm just trying to tell you is, when you sue somebody, don't always think you win. And if you're the one who sued and you lose, you always have to pay the defendant. So the fact that you sue someone does not always mean you are the one that will win. No, you might lose and you will pay costs. And also the judgment or the award won't be in your favor. So before you sue, guys, I'm a cost. So why do I say Supreme Court? So the Court of Appeal, applying the principles set in the Supreme Court. So I was right. I was going to say Supreme Court. Applying the principles of the Supreme Court in the case of Koget Palm Olive Zambia Limited and Shimyu and others. If I got it correct, I'm going to Shimyu and others. Appeal number 181 of 2005. They were referring to a matter, they're referring to a case, Printing Numerical Registration Company versus Simpson. Now, this case brought about the aspect of a contract to say it is made between parties of a full age who have a competent understanding and have the liberty to actually contract or enter into this contractual agreement that is entered into freely, and the court only enforce the contract, and they do not at any point change the provisions of the contract. So they enforce the contract as it is and read into it. So if it's entered into freely, voluntarily, without any coercion, fraud, mistake, they must abide by what you agreed. And they stated that, having looked at the contract, which is the loan agreement, because a contract can be anything, so this one was a loan agreement. Clause number 9, 10, 11, 12 were clear about the events that were to occur when you default, and that House Financial Services Limited were given the right to seize the security, and they were given the right to sell that security in the event that you seriously default on that actual or particular loan. All right? So, they said, well, House Financial Services Limited did not do anything illegal. They had the right because it was provided for in the contract agreement between you two. And therefore, what they did was fine. So we cannot give you damages because you didn't suffer any injuries. You agreed to this. You signed for it. And this is a contractual agreement. And as stated by the Supreme Court, when you enter into an agreement, the job of the court is not to turn away the terms or interfere with the terms. Let them be as they are, and we just enforce the contract as it is. Now, what we learn from this case first and foremost is this. A contract is a legally binding agreement entered into between two parties of full age who have a complete understanding and have a liberty to contract. And that it is the parties that come up with the terms and conditions. And when they outline these terms and conditions, and when you sign or assent to that document, you bind yourselves to the terms and provisions clearly provided for in that contract. And that only a contract that is free from any irregularities is a contract that the courts can enforce by looking at the actual terms. And that the courts will never, if the contract was done in the right manner, play around with it, unless they feel that the person who made the contract was trying to get an advantage, so it will be made against you. There are other cases that we can look at. But a valid contract is one which two parties consentingly agreed to, signed, and the court will enforce it. They won't do anything else. They'll enforce it. So they will always read into that particular contract. Therefore, when you enter into a loan agreement, always make sure you read each and every provision. Ask the other party, can we change this? Can we change this? Because it's a voluntary agreement entered into between the parties. This is what the court was trying to say. And if you sign, you acknowledge that I understand the terms, and if I fail to pay back and default, this is what will happen, and the other party can therefore come to this court and ask the court that this contract be enforced. This also means to those of you that enter into contracts, if someone breaches your contract, read through the contract and take them to court and enforce it to say, look, we signed the contract, free and fair, and as interpreted by Angela Musonda versus House Financial Services Limited, I have the right to enforce my contract. If someone breaches it, they default on this loan agreement, and this is the security they gave me, so I am going to sell this security. Or you can sell the security, and this case will be your argument. But when it comes to mortgages, you have to get the court order first. But if you have such type of arrangement of collateral, you can sell the property so that you get back your money. So this is a landmark case on the basis of contract law, on the basis of loan agreements, that a loan agreement is just like any other contract. That contract transcends through almost all major laws. Employment, IP, what else? Employment, IP, come on George. Employment, IP, company law, banking law, consumer protection. It crosses everywhere. So it's important for you to understand that a contract is enforced by the courts in the manner in which the parties agreed. And therefore, if you breach the contract, you are in a lot of trouble. So this has been today's episode. Thank you for joining me, and I'll see you some other time. I've been your host as usual, George, and well, ladies and gentlemen, episode number 10. Thank you very much for making it possible. I will see you next time. Peace out.